This is Ellen from Cambridge Immigration Law. I'm the owner and the founding attorney of Cambridge Immigration Law. And we are hosting weekly Instagrams to talk about different immigration topics that are common situations or questions from my clients. Today I want to talk about something that comes up all the time, and that's the difference between getting a green card in the U.S. versus getting it outside the U.S. Before we get started on that, though, I do want to mention that we are very excited about getting people to become U.S. citizens at any time. But especially this year with a big election coming in November, we would love to get many more people to become citizens so that they vote. And vote for whomever they want, but that they vote. And so to get people motivated to file their citizenship applications before July 4th of this year, we are taking, in 2024, we're taking $2,024 off our legal fees for citizenship applications. This is a huge discount. Depends on how your case, what kind of case you have, but in some cases it's over a 50% discount on our legal fees. So please, become a citizen if you're eligible, and do it with us here at Cambridge Immigration Law before July 4th. We can't guarantee that you will be a citizen by November, but it's possible. Some of the offices are definitely processing cases fast enough. Okay, so back to our topic for today. So getting a green card in the U.S. versus from outside the United States. A few terms to clear up that are confusing to people. Green card means the card that a person gets when they're a permanent immigrant to the United States. So people don't really get green cards from an embassy. They get it once they come into the United States. So when I say you get a green card in the U.S., I'm talking about a process where a person's in the United States and is applying here in the United States and then ultimately gets the green card while they're in the United States. The green card from outside the United States is actually an immigrant visa petition process where the person gets an immigrant visa in their passport, uses that to enter the United States, and once they're in the United States, the green card is sent to them. And so the immigrant petition is the I-130 application that's filed for people in or outside the United States, and then the immigrant visa is the stamp essentially that's put into the passport. So adjustment of status is what it's called. I'm going to let my dog outside. He's a little bit whiny right now. So we have an office dog named Harry. So adjustment of status, again, is the process that a person undertakes when they're getting a green card in the United States. Consular processing is what we call the process when a person is getting it through an embassy. And an immigrant visa application is kind of like the adjustment of status application, but that's only done if you're at an embassy. Okay, so why would I get a green card in the U.S. versus at an embassy? So there's one main reason why people will get it in the U.S. versus outside the United States, and that reason is that they don't have status in the United States that allows them to stay to get the green card in the United States. There's a big exception to that. So immediate relatives who are spouses of U.S. citizens, children under 21 of U.S. citizens, and that's biological children, adopted children, stepchildren, and also parents whose children are over 21 and U.S. citizens. Those people can be out of status in the United States and get their green card as long as there aren't some other issues. But being out of status isn't enough of a problem to make them have to get their green card outside the United States. Other people that are not those relatives or employees, for instance, have to get their green cards outside the United States if they don't have status in the United States that'll hold them over until they apply for the green card. There could be other issues that make their cases problematic, but one huge thing is just the processing time for non-immediate relatives. It can be so long, years, decades, that a person just is not going to be able to stay in the United States that whole time to get the green card, or they've never been in the United States and they'll do it from an embassy. Okay, so adjustment of status is the process of getting the green card in the United States. And the way that works is if a person's an immediate relative, or what's called their visa petition is current, then they'll file for adjustment of status here in the United States. Immediate relatives will file the I-130 petition, which is the immigrant petition, along with the adjustment of status application. People who are non-immediate relatives, depending on the situation, may also file the I-130, or their I-130 may have been filed years ago, and they'll just file the adjustment of status application in the United States. With those applications, people apply for a temporary work permit, a temporary travel document, they'll submit a medical exam, they'll submit proof of financial sponsorship and ability to support by the petitioner or somebody else. And they'll also, as we discussed, show their proof of status, the maintenance of status in the United States the whole time they've been in the United States.
Ellen, we have a question.
Okay.
Is one process faster than the other?
Generally, right now, adjustment of status is faster. So the question was, which process is faster? And I think historically, adjustment of status is always faster. For the most part, adjustment of status in the United States is faster than consular processing. And I, for many reasons, prefer adjustment of status over consular processing when it's possible, because my clients are here in the United States. The family, the couple is together while this process is going on, but also because generally it's going to be a faster process. It's a good question. So we file the applications I mentioned, the I-130, the 45, the 765, the I-131, the 693, and the 864, along with ID documents and proof of relationship that's necessary. We file that with USCIS, and we'll get receipts for those applications. Depending on your case, you may or may not get a biometrics notice. Generally, if you haven't had biometrics in the U.S. in the last 10 years, you'll get a biometrics notice. And then depending on your case, the next step may be a request for evidence. If you missed something in your submission, or the government somehow sees your case incorrectly and asks for something you've already sent in, which is common, or they ask for other redundant information. So if you get a request for evidence, you need to respond to that. Then, yes?
One more question. Do both processes require interviews with an officer?
Good question. Okay, so do the processes require interviews? So with adjustment of status, again, after filing receipts, biometrics, you may or may not have an interview. This has been a big change since, I think it was October of 22, when the government decided to reduce the number of interviews for adjustment of status applications. So what we say is a really well-filed, well-prepared adjustment of status application now in the United States should not get an interview. It's not impossible, and we get them every once in a while, but good cases are just getting approved without any interview in the United States. On the other hand, to answer the question of the person on Instagram, is that yes, you will have an interview if you are doing if you're doing consular processing in embassy. They could be actually an interview here in the United States for the petitioner. That's not super common, but every single immigrant visa application will have an interview at an embassy. Okay, so again, back to adjustment of status. It's in the United States, and again, it may end with or without an interview. So in some cases, adjustment of status is just one package that's filed, and then the next step is an approval. After the approval, the green card comes about 2 weeks later, as does the Social Security card. But some cases for adjustment of status are in different stages based on the type of case, and also based on whether the government sends you an RFE, a request for evidence, or asks for an interview. Now, the process for consular processing is always going to be at least 3 steps. And those steps are going to be filing the I-130, that's the immigrant petition, or the I-140 if you're doing a work-based visa, a work-based green card, I-130, I-140 in the United States. Once that case is approved and the priority date is current, the case will get sent to another agency in the United States, the National Visa Center. At that point, the applicant will submit an immigrant visa application and an affidavit of support, so the DS-260 and the I-864. Sometimes there's back and forth with the National Visa Center asking for more information. Again, like I said before, asking for redundant information. And then once the National Visa Center documentarily approves the case, then the case will go to the embassy. So these 3 steps always happen in consular processing. There could be, like I said, some back and forth with RFEs, At the embassy, there could be multiple interviews. So, the minimum is going to be 3 interactions with the government, but it certainly could be more. Let's see. So again, with consular processing and adjustment of status, the big thing to know about is that many consular processing cases are non-immediate relatives, which means people file an I-130 petition and then they're put on a wait list, which essentially means there's not enough green cards or immigrant visas in a particular year to give to everyone who applies in different categories. The term that's used for the wait list really is called a priority date. That's the date that the I-130 or I-140 is filed. That date will be measured against dates that are listed on the visa bulletin that's published monthly by the Department of State. So really, to see where you are on the wait list, you're using your priority date and seeing the date on the visa bulletin. If your priority date is before the date on the visa bulletin, then your case is called current and you can proceed to the next steps of the adjustment of status in some cases, or the consular processing. If your priority date is after the date that's listed on the National Visa Center, you have to wait. You can't go to the next step of adjustment of status or the immigrant visa application. We've had some really disappointing changes to the priority dates in the past year, especially with spouses of U.S. citizens, which for a long time were always current. So these are people that weren't immediate relatives, but always could file the adjustment of status application in the one shot that we talked about a few minutes ago. Now there's a, what are we on? At least a 6-month backlog, but the 6-month backlog has not changed in a very long time. So it's really frustrating for people that they cannot get to the next step of their process, which is the adjustment of status application or their consular processing. And so I think we have 1 more minute. And so we work on these cases all the time. We love them. We love working with our clients. We love keeping them united. So if we can do an adjustment of status application and that's what you want to do, that's what we always prefer. But we also work on consular processing. So reach out to us if you need any help in your immigration journey. And remember, we're excited to help people become U.S. citizens this year, this big election year. So if you file your citizenship application with us before July 4th, you're getting a $2,024 discount to celebrate becoming a U.S. citizen this year.